In the last part of the previous lecture, I discussed the abolitionist argument from caprice. So far I've discussed it without any reference to race, but there's an important version of the argument that centers on racism in the USA. The argument concludes that the death penalty in the United States is presently unjust because racial factors influence the behavior of prosecutors and juries, and maybe that of judges and police officers. There's substantial empirical evidence that convicted black murderers in the United States are more likely to be executed than convicted white murderers. The research holds constant a wide range of other variables that could influence sentencing outcomes. There's no evidence, for example, that black murderers kill under circumstances that make them more culpable on average than white murderers. If black murderers tended to use especially inhumane methods, for example, then that difference might explain the higher rate at which they're executed, without using the hypothesis that racial bias is at work. But there are no such differences between the races. So a plausible explanation for the racial disparity in sentencing is that some of the decision makers, such as prosecutors and jurors, are taking race into account. Blacks convicted of murdering whites are also more likely to be executed than blacks convicted of murdering blacks, whites convicted of murdering whites, or whites convicted of murdering blacks. These correlations are statistically significant and consistent with the nation's history of racist criminal justice. The documented effects derive partly from the decisions of prosecutors to seek the death penalty, and partly from the sentencing verdicts of juries. No one's been able to explain the statistical correlation between racial variables and executions without adopting the hypothesis that race plays a role. This doesn't prove that any juror or prosecutor is consciously acting from racist motives, but it suggests that at least subconsciously many are treating defendants differently because of race, and surely some of them are consciously indulging in racist thinking. On the basis of this empirical evidence, many abolitionists contend that justice requires a new moratorium on the death penalty in the United States until the states can offer reasonable assurances that racial factors will no longer influence capital sentencing. Because no one currently has a feasible method for neutralizing the influence of race in capital sentencing, such a moratorium would be in place for many years to come. Some retentionists contest the empirical evidence, but others accept it while denying that it makes a good case for a moratorium. Some argue that the current death penalty system in the United States is not unjust because, assuming that all capital murder convicts deserve to be executed, the state never knowingly gives anyone a harsher sentence than he deserves, despite the fact that white murderers, and blacks who murder blacks, are more likely to get less punishment than they deserve. This argument has surprising implications. Imagine a facially racist statute that authorizes juries to impose death sentences only on blacks, not on whites, who are convicted of capital murder. Assuming again that all capital murder convicts deserve to be executed, this statute gives no one anything worse than he deserves. Nevertheless, few retentionists would support the facially racist statute, so they can't consistently defend the current death penalty system by appealing to the fact that it gives no one a harsher sentence than he deserves. So what should retentionists say if they accept the empirical studies about the influence of race on executions? They should, in that case, concede that injustice plagues the current system. They should distinguish the facially racist statute from the current system by arguing that whereas the state is entirely responsible for the facially racist statute, it's not morally responsible for the racial injustice of the current system. Instead, the responsibility falls entirely on racially biased prosecutors and jurors. Justice doesn't require the state to institute a moratorium on the death penalty just because some actors within the system are racially biased. This is the position taken by the Supreme Court in the 1987 case of McCluskey v. Kemp, which you were assigned to read. In this case, a black man named Warren McCluskey was convicted of murdering a white man, an off-duty police officer, during an armed robbery. McCluskey was sentenced to death. On appeal, he presented statistical evidence of racial bias in capital sentencing, in violation of the 8th and 14th Amendments. The Punishments Clause of the 8th Amendment states that cruel and unusual punishments shall not be inflicted. The Equal Protection Clause of the 14th Amendment reads, "No state shall make or enforce any law which shall deny to any person within its jurisdiction the equal protection of the laws." The court held that a black defendant can't get his death sentence overturned simply by proving that black defendants are more likely to be executed than similarly situated white defendants in his state. Rather, a black defendant must carry the much greater burden of proving that racial factors adversely influenced decision-makers in his specific case, for example, his prosecutor or his jury. Such evidence is almost never available, so McCluskey made the death penalty almost impossible to challenge in court on grounds of racial bias. The ruling in McCluskey stands today, but it remains very controversial. Some commentators accept arguments such as those advanced in your assigned reading by Stephen Nathanson. Nathanson published this article before McCluskey's case was decided, perhaps in the hope of influencing the court. Nathanson's basic claim is that the justice of punishment or reward doesn't depend solely on what the individuals deserve. However, he recognizes that not all violations of comparative justice are wrong, all things considered. For example, he thinks it's okay for highway patrol officers to ticket only a fraction of the drivers who exceed the speed limit. But Nathanson insists that not every reason for choosing to ticket one speeder over another is compatible with justice. It's okay to ticket every 10th speeder, or only those who exceed the speed limit by more than 20 miles per hour, but it's not okay to ticket only speeders with facial hair. Nathanson expects his reader to find it intuitively obvious that it would be unjust for police to ticket only speeders with facial hair. He doesn't try to convince you of this or tell you why. Of course, having facial hair is morally irrelevant and has nothing to do with the wrongness of speeding, but neither does being the 10th speeder in a row. Yet Nathanson says choosing on that basis is okay. Perhaps the idea is that facial hair is a morally irrelevant characteristic of the person that individuals have a right to possess without being made into second-class citizens as a result. Being a black person is also such a characteristic, and African Americans have a history of racial oppression that men with facial hair don't have. If deliberate discrimination against facial hair is unjust, then of course deliberate discrimination against black people is unjust. Remember, however, that the petitioner in the McCluskey case doesn't allege deliberate discrimination on the part of the state of Georgia. He simply alleges that as a black man who killed a white man, he has a greater chance of being executed in Georgia than if the racial facts of his case were different. Nathanson claims that once a state knows that racial factors are playing a role in its death penalty system, justice demands a moratorium on the death penalty altogether, even if lawmakers aren't engaged in deliberate racism. This is a provocative stand that I invite you to ponder for yourself.